Trespassing land is so easy that, you know, what kind of stuff do examiners throw in there to juice it up a bit? One is watch out for when you had consent to enter but it expired. We saw that with the fence post case. They had consent to build a snow fence. County Highway Department went to the farmer, said, can we put up a snow fence for the winter? Farmer set a course. The winter is over. They took away the snow fence. They left a post in. They didn't know they'd left the post in. Farmer comes along with the tractor, hits the post, tips over, farmer dies. Farmer sues them for trespass the land. They say, we never intended to hurt you. It's certainly not battery. We didn't intend it. We didn't even know about the touching. The plaintiff says, I'm suing for the damage to the farmer to his body as a damage in trespass the land. You were trespassing on my land. We had consent to be there. And we had no intent to leave the post there. We forgot about it. Do you have conduct causing an entry? Yeah. The entry was the post. They hammered it in. Did they intend that entry? Yes, they did. When consent expired, that intentional entry now became without consent. Did it cause damage? Yeah, it caused the guy to die. You get those damages in trespass. So the setup in a lot of exam questions in trespass to land is where they get down to consent and privilege issues because the rest of the prima facie case is so easy. So watch out for expired consent or consent that you exceeded. We saw that one where I invited people to dinner at my house. I didn't know them all that well. They were students. One of them wanders up deep into the bedroom, opens the drawer, and starts going through the lingerie. That's trespass at that point. You did have consent to be on the property. You may have had consent to go upstairs to go to the washroom or bathroom or something, but you probably didn't have consent to the bedroom. You argue the door was wide open and everything, all the lights were on. I thought I could step in and look around. You clearly didn't have consent to start messing around with the dresser. So it's trespass at that point. So watch out for consent exceeded or expired as one of the ways of complicating a trespass to land action. Airspace, not much of an issue anymore. In common law, you own the land all the way up to the heavens and all the way down to hell, etc. So you owned everything below and above you. Now it's decided by practical terms of what's the practical use made or available to you on the land. And so the immediate reaches of the land is a phrase a number of courts use, saying if it's above the immediate reaches that you can practically use, you don't really have a possessory interest anymore, and therefore find another tort for it. If it's down below you and it's a big cave below you, and you might sometime want to use that, and it is usable, then someone using that cave is trespassing on your land. If it's someone carved something 300 feet down through granite, like the New York subway, you didn't have any possessory interest because there was no practical way you ever would have used granite 300 feet down. So it's a common sense approach on airspace and below you. Here you got to watch out for damages because trespass to land is a useful tort not only for damage to land, but for any damage to the person or personal property caused by the trespass. So you start with the rule of damages. You don't need actual damages for trespass to land. There's no requirement that you suffer actual damage. If someone comes onto your land without consent, they do it intentionally, that caused no damage whatsoever, you can still sue them for trespass to land. You'll get a judgment in your favor for trespass to land, and you'll get at least nominal damages. You'll get a buck. Nominal damage means where there's no actual damage. So you have no actual damages requirement. Trespass to land is a useful action for deciding who does have the possessory right. So the common law has never required actual damage. In your case book, you've got I think a Washington case that says you need actual damage in our state where you're trespassing with particulate matters. You won't face that on the exam. It's not some general rule. You'll have to look up those kind of issues when you get to a particular state you're practicing in. Generally speaking, we're sticking with the approach that if there's a tangible entry, you a rock, a person, you've got trespass to land. If it's invisible, like a smell or light or noise or that, you need another tort, and another tort's a more practical way of going about it, nuisance. So with damages, we start out with you don't need damages. The second rule is that you get all damages caused. Trespass to land is not limited to land damage. The third thing to watch out for is who can sue for those damages. The courts generally say you and your immediate family. You're the owner, your immediate family can sue too. Why? Because the fact their immediate family gives them an exclusive right of possession. So if they're hurt by some defendant's trespass while on the land, they can sue and get the damage for their personal injury, even though they're not the owner of the land. They said, my father owns it, therefore I share in the exclusive right of possession vis-a-vis this guy. I too could have told you to leave, and you'll be compensated also as a plaintiff. So members of the immediate family. So watch out for a fact pattern where you got the owner's brother, and a friend over, and all three get hurt. The friend can't sue. The friend has no possessory interest at all. The courts have limited to members of the immediate family. If you've got other facts where they've told the friend, you are now living here, you can stay in our attic. If they've given the person some exclusive possessory rights, then they have them vis-a-vis the defendant, and you move forward with that. So I can have an exclusive right of possession even though I'm not in possession. If I own a house here in the city, and I own a house in the country, that doesn't mean since I'm not using the country house, you can go sit in it. That's a trespass. Why? I have the immediate right of possession. And you're interfering with my right to exclude whoever I want from that property. So it's a trespass whether I'm in possession or not. Remember, if someone takes away consent, don't get mixed up that was saying they can't, the store, a restaurant can't throw you out of the restaurant. There's laws against that. The fact is they can throw you out of a restaurant for any reason they want, unless statutes have been passed saying they can't throw you out. And the only statutes or the standard was they can't throw you out because of your race or your religion or your gender. But you have to watch out. If a store owner tells a gay person to get out because they're gay and they hate gays, most states say they've removed your consent, you better leave. It's only statutes that come up with prohibited reasons, and we don't have those statutes. So don't assume that you've got rights to be in certain places because they're commercial and the rest of it. If that's not given in the fact pattern, then when the owner or the exclusive possessor takes away your consent to be there, it's gone, you're a trespasser after that. Conversion, no, trespass to chattel. Chattel is distinguished from land. Land is land and anything permanently attached to land, like a house, a pillar, whatever, is considered land. So condominium is way up there in the sky, it's nowhere near the land, but it's permanently attached to the land through the other condominiums and the posts, etc. It's all land. A telephone pole is real estate. A tree is real estate. If you cut the tree down, it's no longer land. Now it's a chattel. Chattel is just a synonym for personal property. The chattels aren't attached to land. They're things that are possessed, but they're not land. So we're talking about now when someone messes with your car, your computer, your clothing, your pen, personal property. When is it a tort for messing with personal property? You sue for trespass to chattel. Remember that animals that are owned are chattels. Animals that are not owned, that are wild, no one owns them, they're not chattels, they're not personal property, they're not property. Trespass to chattel is conduct intended to cause and causing interference with another's chattel. I want to say it another way, interference with the possessory rights to personal property without consent and without privilege.